Good evening, friends. Let us dive into another case law, which is Nandini Sunder versus State of Chhatisgarh of 2011. We all know SPOs who were not fully qualified, illiterate, were given arms aimed at controlling, countering, mitigating, or otherwise eliminating vast Naxalite activities in the state of Chhattisgarh. So a public contest litigation was filed that it is causing more harm than relief. So after going lengthy arguments and justifications, the Honorable Bench gave its judgment in the form order. So it said that we order that, firstly, the state of Chhattisgarh immediately seize and desist from using SPOs in any manner or form in any activity directly or indirectly aimed at controlling, countering, mitigating, or otherwise eliminating MAOIST Naxalite activities in the state of Chhattisgarh. The Union of India to seize and desist forthwith from using any of its funds in supporting directly or indirectly the recruitment of SPOs for the purpose of engaging in any form of counter-insurgency activities against MAOIST Naxalite groups. The state of Chhattisgarh shall forthwith make every effort to recall all firearms issued to any of the SPOs, whether current or former, along with any and all accoutrements and accessories issued to use such firearms. The word firearm as used shall include any and all form of guns, rifles, launchers of whatsoever caliber. The state of Chhattisgarh shall forthwith make arrangements to provide appropriate security and undertake such measures as are necessary and within bounds of constitutional permissibility to protect the lives of those who had been employed as SPO previously or who had been given any initial orders of selection or appointment from any and all forces, including but not limited to MAOISTs and Naxalites. The state of Chhattisgarh shall take all appropriate measures to prevent the operation of any group, including but not limited to Salva Judum and Koa commandos, that in any manner or form seeks to take law into private hands, act unconstitutionally, or otherwise violate the human rights of any person. The measures to be taken by the state of Chhattisgarh shall include, but not be limited to, investigation of all previously inappropriately or incompletely investigated instances of allied criminal activities of Salva Judum or those popularly known as Koa commandos, filing of appropriate FIR and diligent prosecution. In addition to the above, we hold that appointments of SPOs to perform any of the duties of regular police officers other than those specified in Section 23, Subclass 1H and Section 23, Subclass 1I of Chhatisgarh Police Act 2007 to be unconstitutional. We further hold that tribe youth who had been previously engaged as SPOs in counter-insurgency activities in whatsoever form against MAOIST Naxalites may be employed as SPO to perform duties limited to those enumerated in Section 23 Subclass 1H and 23 Subclass 1I of CPA 2007, provided that they have not engaged in any activity, whether as a part of their duties as SPOs, engaged in any form of counter-insurgency activities against MAOIST Naxalite and left-wing extremism, or in their own individual or private capacities, they may be deemed to be violation of human rights of other individuals or violation of any disciplinary code or criminal laws that they were lawfully subject to. Now, matter relating to allegation by Swami Agnivesh and allied incident in March 2011. We now turn our attention to the allegations made by Swami Agnivesh with regard to the incidents of violence perpetrated against and in the village of Morpalli, Tadmelta, Tadmetla, and Timapuram, as well as incidents of violence allegedly perpetrated by people including SPOs, Kua commandos, and or members of Salva Judum, Angesh Swami Agnivesh, and other traveling with him in March 2011 to provide humanitarian aid to victims of violence in the said village. In this regard, we note the affidavit filed by the state of Chhattisgarh in response to above. We note with dismay that the affidavit appeared to be nothing more than an attempt at self-justification and rationalization, rather than an acknowledgement of constitutional responsibility to take such instances of violence seriously. The affidavit of the state of Chhattisgarh is itself an admission that violent incidents had occurred in the above named three villages, and also that incidents of violence had been perpetrated by various people against Swami Agnivesh and his companions. We note that the state of Chhattisgarh has offered to constitute an inquiry commission headed by a sitting or a retired judge of the High Court. However, we are of the opinion that these measures are inadequate, and given the situation in Chhattisgarh, as extensively discussed by us, unlikely to lead to any satisfactory result under the law. The court had previously noted that inquiry commissions, such as the one offered by the state of Chhattisgarh, may at best lead to prevention of such incidents in future. They, however, do not fulfill the requirement of the law that crime against citizens be fully investigated and those engaging in criminal activities be punished by law. That's all. God bless you all. See you again.